Thank you very much, Chairman. The trademark registration and what it shows on the register, mark, the goods, should define scope. But how do aspects not shown on the register, such as the reputation of the mark, affect scope? It's been the law since canon that one goes beyond the registration. One looks at marketplace use, one looks at reputation. And I'm going to look at some of the older cases, both here and in Europe, and some more newer cases, more recent cases as well. And the approach seems to be driven by what the courts consider to be consumer perception of the registered mark. But does that factor serve only to increase or enhance scope, rather than reduce it? And how can commercial actors conduct themselves with certainty, given the nature of the inquiry into marketplace use that may lie behind the face of the registration? Incidentally, I've got, as well as your slides, you'll see there's a sort of notes and case extracts. Inevitably, there's large numbers of paragraphs from ECJ judgments. I'm not going to read them out. Some of them are in the slides, but some of them are just in the extracts. So the starting point is, this is the difference between Michael and me, I get to put up some pretty pictures. The starting point is, of course, that the earlier mark, the more distinctive the earlier mark, the greater will be the likelihood of confusion. And that's the mantra that has been repeated since CIPIL. Been repeated so often it's almost devoid of content. And we know from Lloyd that the more similar the goods or services covered and the more distinctive the earlier mark, the greater will be the likelihood of confusion. Now in canon, the first part of the referred question was, can you take account of reputation when you're focusing on the assessment of similarity of the goods and services? And the MGM in the United Kingdom argued in that case that you shouldn't be able to do so because the assessment of the similarity of goods and services was an objective and independent threshold question, and it would be difficult and prolonged, and only prolong the proceedings, to get into an assessment of reputation purely for the purposes of assessment of similarity of goods and services. The CJU disagreed, and the answer to that question was that marks of a highly distinctive character, per se, as a result of reputation, enjoy broader protection. The well-known canon factors of similarity, nature of the use, the end users, method of use, and so on, all relevant circumstances. And then the ultimate answer was that the distinctive character of the earlier mark, and in particular its reputation, must be taken into account when determining whether the similarity of the goods or services is sufficient to give rise to the likelihood of confusion. So distinctive character is relevant to this assessment, at least on that interpretation. Now, initial reactions to canon and the idea that scope should be increased by reputation were met with some surprise and concern on the part of UK judges. If one takes Mr. Justice Pumphrey's, he then was in brief at first instance, he said that there is a greater likelihood of confusion with very distinctive marks, according to canon. This is a very surprising proposition and perhaps only a presumption of fact, since it can't be a legal issue, since normally it's easier to distinguish a well-known word mark from others close to it. It seems to make more sense when one comes to consider device marks. I have difficulty understanding how it can affect the question of similarity of goods, but that is the law. And it seems to be that the ECJ's approach is predicated on the idea that that's the way that people think, that if a mark is better known because of use, they're more likely to confuse it with other signs, and it should have a greater scope of protection. And it sort of got me thinking, is that right? Is that the way our minds work? And I looked at on the internet for someone. These are pictures of people that profess to be lookalikes of Sean Connery, and they make a living out of this. And these are pictures from their websites. That's not Sean Connery. No, that's Sean Connery. Closer. And there's the real thing. And it struck me that actually it's not right that if you know Sean Connery because of his extensive exposure, then in fact you can normally tell the difference. It doesn't mean that you're more likely to confuse. It's Justice Pumphrey was absolutely right, that it is actually sort of counterintuitive that that's the way that public perception works. But anyway, as he said, that's the law. I wanted to move on to the next sort of case that deals with this issue, the Adidas 2 case. This is not the initial one, the Fitness World one. This is the second one. There's another two-stripe versus three-striped case. And the Dutch court referred to the ECJ this question here that I've extracted on the slide. Should account be taken of the general interest in ensuring that the availability of given signs is not unduly restricted for other traders offering the goods or services concerned? In other words, should the need to keep free doctrine play any role in the scope of infringement? And the question there was really, should, I think the Dutch court's premise was that in general there's quite a lot of stripes out there, and therefore that you need to keep free, you need to be able to give freedom of action to traders there. And the court's answer to that was, although need to keep free plays an important role when it comes to registration, so the windsurfing Kenzie case and so on, it is not part of the structure of provisions when it comes to infringement. And in particular, they cited the 10th recital, which you'll see on page 3 of your notes, in which the directives, the 10th recital says, depends on numerous elements, and in particular the recognition of the trademark on the market, the association which can be made between the mark and sign, the degree of similarity, and so on. And what they said is, you won't find in that list any reference to the need to keep free. And then they went on to say this in the part that I've extracted on the slide. Really, the need to keep free can't be one of the factors because it's no part of perception. So, although it may be, I think what they were saying there, incidentally, by the way, it also applies to 5.2 cases. What they were saying there was that whatever the merits of need to keep free as a sort of public policy argument or competition argument, it doesn't form part of the way that people perceive marks, and therefore is no part of the assessment. And one can see, therefore, that it might be said to sort of slightly cut across Canon in this sense that Canon is saying, well, you can take account of marketplace perceptions and certainly to increase scope. But what they're saying here is you can't take account of public perception to decrease scope because that's not the way that people actually perceive. And again, I slightly question that, because if there are a lot of two stripes out there, you can characterise that as a sort of policy argument of the need to keep free. But another way of looking at it is people are used to seeing a lot of stripes, and therefore it should form part of the scope. We then move on to something a bit more recent, the Specsavers case. And this case did import some restriction on the scope via public perception. First of all, to view things from the proprietor's point of view, the first question was the mark, by the way, the sort of the black the monochrome ovals there, overlapping ovals, that was the trademark, and of course the use had always been in the form of the Specsavers logo. They'd never used that logo on its own. And the question that was referred by the Court of Appeal was, is it relevant that it's always being used in a particular colour? Is that part of the assessment of scope? And that increased scope, can that make the claimant's case any better? That was one of the questions. And the ECJ's answer to that was first of all, to deal with some of the UK arguments. And the UK arguments were, again, a bit similar to Canon, in the sense that they said that once you start departing from the trademarks register and what is shown on the register, you're going to get into trouble, and it's going to lead to absurd and contradictory results. For example, said the UK in this case, imagine if the use of the earlier mark had been in green, and the complained of use was in blue. Does that help you or hinder you? Do you have a restricted scope as a result of your use, or does it only work one way to restrict, to enhance scope? And would that potentially mean that a mark that had never been used is in a better position than a mark that had been used extensively? Anyway, none of that mattered to the court. The court said, really, you've got to take into account the way the mark has been used, irrespective of the fact that it's simply a monochrome mark, and therefore that does affect the likelihood of confusion, certainly for the purposes of enhancing scope. But, and this is quite an important and often overlooked part of the judgment, it does also matter whether the defendant has a reputation for its colour. So one of the other questions was, does it matter that Asda has its own reputation in green? And is that relevant to public perception? And the court said, yes, it does matter. So in other words, the defendant's use and the public perception of that use may serve effectively to restrict scope. It may serve to diminish the likelihood of confusion in confusion cases, and it also may present less likelihood of link in Article 5.2 cases, and also may indeed give a due cause argument to the defendant in 5.2 cases. So there was an example, perhaps a rare example, of the scope being somewhat restricted by something that lies behind the register, something that marketplace reputation and consumer perception. But it all still does depend, I would say, on consumer perception, at least the court's understanding of that in any particular case. That's the key finding of Specsavers. Those two on the slide, sorry, I should forward on those. So the next case is ASOS and ASOS, or ASOS and ASOS, I'm not quite sure how to pronounce these. This is a UK infringement action. It was a trademark infringement action in the High Court, and then an appeal before the Court of Appeal. And basically you had the earlier mark holder, who was a manufacturer of specialist cycle clothing, and the later user of the ASOS trademark, who sold a very successful online fashion website. And there's an obvious overlap between the goods and an obvious overlap between the marks. And the question was to what extent the earlier mark should be revoked. There was also various defences that were deployed in the cases, bristling with lots of points on other issues, but which I can't talk about today. But the particular issue that's interesting is the finding by Mrs. Justice Rose at first instance, which seemed to be effectively applying this canon principle of whether reputation could be relevant to the assessment of the similarity of the goods and services. And she said this: the judgment of the Court of Justice in canon made clear that this question is not to be assessed simply by looking at the goods in the abstract, but by looking at the goods in the context of the distinctive character of the trademark and its reputation. So the question I must answer is not simply, is a dress similar to a t-shirt, but is a dress similar to an ASOS t-shirt or ASOS t-shirt, bearing in mind the reputation and distinctive character of the ASOS mark. This is an important point in this case, because the reputation of the ASOS mark is as a maker of racing cycling clothing to be worn on a bike. ASOS does not have a separate reputation as makers of casual clothing. Racing cyclists are unlikely to wear dresses and knitwear and so on. And so then she concludes that in those circumstances the goods are not very similar. So in other words, looked at through the prism of the reputation of the earlier mark holder, the scope of infringement would be diminished. An understandable position to take in the light of the case law. However, overturned on appeal, in the Court of Appeal, the Lord Justice Kitchen said that was not a correct approach, that he considered that there was some similarity between the clothing in any event, and the reputation of the earlier mark could not make the clothing less similar in the way that the judge had found. So one gets from that in a sense that the lever of reputation only works one way. It serves to increase scope rather than decrease scope, and it would be surprising for it to be otherwise, other than in circumstances such as the Asda scenario. The next case I wanted to talk about is the Glee case. This is a case which again has lots of points in it, but the particular issue that I wanted to focus on was the finding by the Court of Appeal, who essentially vitiated the first instance trial judgment, but then reached the same conclusion for different reasons. I wanted to focus on the finding by Lord Justice Kitchen that certain evidence, he said, was quite powerful in the sense of being probative of confusion when it was evidence of the wrong way around confusion. Now, the background was that the evidence in question was of people who were aware of the television show and not aware of the claimant's trademark or its business, encountered the claimant's business and then were confused. And Lord Justice Kitchen said in the passages, I haven't got the passages there, but he's found essentially that was relevant on the question of the likelihood of confusion. And he said this, he said, actually, it may be nothing more than a consequence of the order in which a consumer happens to encounter the claimant or the defendant. And he said, to that extent, it was relevant and probative to have people who were examples of wrong way around confusion. So in effect, what he was saying was that people who were, let's say, imbued or steeped in the reputation of the defendant and then encountered the claimant, that could be relevant to the assessment of confusion. And that, I would suggest, is quite a new point in the law of trademarks, because that is a case in which the law is taking account of the defendant's reputation to enhance the scope of the claimant's trademark. And it's the case is still there's another hearing on it and I'm involved in it, so I don't want to say too much more. But it's worth looking at on this point, because the one way of looking at wrong way around confusion is that it is taking account of canon reputation, so to speak, so reputational use that sits behind the mark for sign comparison, but actually looks at the defendant's use rather than the claimant's use. I wanted to talk now about the Iron and Smith case. Are those doing all right for time? Are we, how are we doing, Mr. Chairman? Yeah. The Iron and Smith case is a very interesting case and really does show the, I would suggest, true complexities and the dark recesses of reputation that now need to be explored potentially in any case involving a CTA. Now, the background to the case was that the mark was applied for in Hungary, but the reputation existed only, I think, in the UK and Italy. And the question before the court was, can you take account of the fact, effectively, if it's a CTN, if it's a European trademark, why should that matter? You've got reputation in one part of the community, you've got a national application, or let's say for today's purposes, a use. Another part of the community, job done. You should be able to prevent that. And so the reference to the European Court was, how does this all work, in particular in the light of the previous cases such as Pago, DHL, and so on. Now the court considered those cases, and it started off with Pago. It said that essentially that reputation could be established for a CTM, as you know in the Pago case, some of you, it could be established by use in a single CTM, a single member state. So there's nothing wrong with establishing reputation only in Austria, for example, because that's a significant part of the community, and therefore your action gets off the ground. You fulfill the first part of an Article 9(1)(c) case. Then there's I suppose the other background case to take into account is DHL Express, where the court had looked at the scope of relief in CTM cases and had said that that may depend on the different results that could obtain in different member states. So if, for example, there are linguistic differences in another member state, that may lead to a different result. So that case started to look more not only at whether you qualified for an Article 9(1)(c) action in the first place, whether you had a reputation, but more on the effects. And the court focused on whether there could be different results. Once you ask yourself, where is the damage to the essential function, there could be different results in different member states. So that was getting part of the way to the answer. And then, of course, there was the Leno-Merkin case, which was a revocation case. But there was an overall suggestion in that case that one one reading at least, one effectively rubbed out the borders of the EU and treated it as one market. So that might have had a bearing as well. But none of them really directly answer this question about whether, if you've got a reputation in one or two member states for a CTM, therefore you've qualified for the extended form action, does that have a bearing on a member state in which you don't have that reputation? So what was the court's answer? Well, it was essentially this, that even if the earlier mark is not known to a significant part of the relevant public in the member states, that's Hungary, so it's not known in Hungary, a significant part, it's conceivable that a commercially significant part of the latter may be familiar with it and may make a connection, and that there is taking account of all the relevant factors, either actual or present injury. Now, the first question is what they mean by a commercially significant part of the public. It's pretty clear that it must be a narrower section than the significant part of the public that Mr. Justice Arnold dealt with in Interflora, upheld by the Court of Appeal. So we already know that that was acceptable. It doesn't have to be a majority, could be a significant part. But this is a smaller part again. And it's really quite difficult to know how fine or small this group is. Is it that they're talking about expat Brits living in Budapest who are aware of the use in London? Or expat Italians who happen to be living in Budapest? And does there have to be a large community of them? Little guidance is provided by the obvious places to look, the Advocate General's opinion, because the Advocate General seemed to have a higher number of people in mind. He said, in my view, the consumers who establish that link must account for such a weighty proportion of the relevant public in the member state concerned that the commercial implications will be considerable. So it was weighty proportion and considerable commercial effects. That wasn't directly adopted. And so it's quite difficult to know. And if you look in the paragraph that's up on the slide, clearly it's, on the logic of the paragraph, it's less than a significant part. So just to sort of think about this, we've now left the trademark registration far behind. We are now looking at reputation really quite away from the trademark. And we may be looking at reputation in the recesses of a subsection of a sub-community in a single member state in order to establish whether the use in that member state infringes or whether it involves confusion or 91C cases. And all of that is getting quite far away from the trademark itself. So just some concluding thoughts. The importance of reputation seems to be based upon the court's assumptions as to public perception. And the initial view, at least in this country, was that the canon approach of assuming that more reputation means more likely to confuse or more likely to link isn't necessarily right as a matter of public perception, but it's the law. It seems counterintuitive in some circumstances. What's also interesting is that it only ever seems to work to enhance, or mainly enhance its scope rather than restrict it. Whereas if it were based purely on perception, and if perception was the touchstone, it should be able to work both ways. Looking beyond the trademark registration certainly involves a difficult and detailed and uncertain factual inquiry, as the UK submitted in the original Canon case, and turns trademark actions into potentially prolonged and expensive proceedings. And the Iron and Smith case shows that there may be some very surprising place and dark recesses that one has to look to find the answer to these cases. Thank you very much.